everyone. I'm Steven Teske, retired judge, former prosecutor, and welcome to episode 2 in this series titled Minneapolis Under Siege, Myths versus Law. And this is, of course, the Teske Brief, where we separate law from loud talking points. This episode is titled Absolute Immunity? No. Absolute Misinformation. And today's episode is about a phrase that's been thrown around a lot lately, especially after the fatal ICE shooting in Minneapolis. The phrase is absolute immunity. And I'm going to say this calmly, clearly, and right up front. Federal law enforcement officers do not have absolute immunity. Not in civil law, not in criminal law, not ever. And if you're hearing otherwise, you're being misled. Before we go any further, let me explain why I'm comfortable speaking on this. In addition to serving as a judge and a prosecutor, I also served as a special assistant attorney general for the state of Georgia, where I defended state employees in federal civil rights lawsuits filed under Section 1983. So I spent years litigating immunity. Absolute immunity, qualified immunity, not as a talking point, but as a real legal defense. I know how these doctrines actually work in court. Now, before we talk doctrine, let's start where court always should, and that's with the evidence. So, the New York Times did something important here. They synchronized every available video angle, body camera footage, bystander videos, street footage, and they did it frame by frame. When those videos are aligned, 3 facts matter. First, the ICE agent who fired was not in the direct path of the vehicle at the moment shots were fired. Second, he moves laterally away from the SUV before shooting. And third, 2 of the 3 bullets were fired through the driver's side window, not head on. Now, once the footage is synchronized, the claim that the agent was run over, well, it simply does not hold up. Now, let's watch and listen to the video. Moments before the shooting and during the shooting so you can watch and see what I just described.
The agent's left hand is still against the vehicle and gripping his phone. We see as he fires, it's recording the clouds and the trees overhead. It's not because the agent is knocked to the ground. The other angle shows he's still standing, continuing to maintain his grip on his phone and his gun, and we see a clear and growing gap between his body and the SUV as he fires a second shot and a third. None of the bullets have the effect of stopping the SUV, but they kill Renée Good. According to our analysis of audio from Agent Ross's cell phone video, this is his reaction.
Now, let's keep in mind that what we just saw does not decide guilt, because that is for a jury that has also heard other evidence and testimony, including from experts, with instructions on how to consider the evidence, along with an explanation of the standard of proof and how to weigh the evidence. But it does decide something critical. At least what we saw means we are no longer dealing with speculation. You see, shortly after the shooting, Vice President J.D. Vance stated that the ICE agent was protected by absolute immunity. And that statement is legally incorrect. And I know he's a lawyer. He's a graduate from Yale Law School. I don't know what he was thinking in the moment when he made that statement, but it's still wrong. Now, absolute immunity is extremely narrow. It applies to functions, not uniforms. Judges, for example, when they're judging, as I was for my 22 years while wearing the robe while on the bench, decisions I made, I had absolute immunity. And there's been a couple times that I was sued and it was dismissed based on absolute immunity. Now, prosecutors also have absolute immunity when they're advocating in court. So, like me, when I was a judge, once I took the robe off and I walked out and made, let's say, because I was chief judge for many years, and I made some administrative decision, and my decision was one for which, I injured somebody. I did not have absolute immunity at that time. It then dropped to qualified immunity. We'll talk about that later. Another group that has absolute immunity would be legislators. That is when they're legislating, when they're in the House chambers or the Senate chambers, and they're in the process of legislating, okay, they have absolute immunity. Again, once they go outside that scope, like a judge, once he or she takes off the robe, they lose absolute immunity. But law enforcement officers, ladies and gentlemen, federal, state, or local, do not receive absolute immunity for use of force despite what the vice president said. And that's not even a close call. What law enforcement officers have instead is qualified immunity, something I mentioned a moment ago. And that distinction matters. Qualified immunity protects officers only when they are performing what is called discretionary acts. That is, decisions that require judgment in rapidly evolving situations. Now, judgment, that is, okay? That's why it's discretionary. In other words, there's not really any rules or laws or custom and practices that are telling them exactly what to do or what not to do. But qualified immunity does not protect ministerial acts. No, opposite of qualified immunity, ministerial acts is where the law, the policy, or training, or custom and practices, it tells or informs the officer exactly what must or must not be done. You can't violate it. And when a plaintiff, that is the person who's claiming a violation of their civil rights, alleges that an officer violated a clear law, policy, or training, or custom and practice kind of requirement, what lawyers call that ministerial duty, immunity does not apply. And at that point, the case does not get dismissed on qualified immunity grounds. Instead, it goes to a jury. Now, let me give you a simple, concrete example. Let's say if an officer is trained clearly and repeatedly that when confronted with a moving vehicle, the proper response is to move out of the vehicle's path rather than fire into it, that training is not a suggestion. That training becomes a ministerial act. Now, of course, there might be in that training, in those circumstances, some exceptions. Like, for example, the car is already heading directly at you and you don't have time to get out of the way because it's so close. So just bear in mind, I'm trying to make this example simple. That training becomes a ministerial duty. So if the allegation is that the officer fired after moving out of the vehicle's path, contrary to how he was trained, that is no longer a discretionary judgment call. It becomes a factual question for a jury. Now, what was the training? Was it clear? Was it followed or violated? And when the allegation is a violation of a ministerial act, a law, policy, or training requirement, there is no immunity shield that ends the case early. Now let's address the most important question directly. Can this ICE agent be criminally prosecuted? And the answer is yes. Legally possible, but it can be difficult. Federal officers are not immune from state criminal law simply because they wear a federal badge. Under the Supremacy Clause, a federal officer avoids state prosecution only if he or she was acting within lawful federal authority and did no more than was necessary and proper to carry out that duty. That is the standard. Now, given the video evidence, legal scholars have noted that finding probable cause would not be a stretch. That does not mean conviction is guaranteed. It means investigation is required. And here's the key point that keeps getting lost. Immunity doctrines do not block criminal investigations. No. In fact, they do not preclude, or that is, they do not pre-decide outcomes. They do not excuse unlawful force. The law guarantees process, not protection from scrutiny. Now let's turn briefly to civil lawsuits, where things get more complicated. Section 1983 was passed after the Civil War to address bad faith state actors, not federal officers. That's why it doesn't apply here, because this was an ICE agent who's a federal officer. So he could not be sued civilly under a Section 1983 claim. The Supreme Court created, though, what's known as a Bivens action, stemming from the Supreme Court case of Bivens versus 6 unknown name agents. That was back in 1971. And it's similar to Section 1983 suits against state and local officials as a stopgap to allow constitutional claims against federal agents. But here's the thing. Over time, the court has narrowed that remedy significantly. It's important to add this clarification. You see, under the current Supreme Court precedent, Bivens actions against federal officers engaged in immigration or border enforcement are generally barred, meaning civil claims against ICE agents face even steeper hurdles than in other federal contexts. I will address the reasons why Bivens was judicially created, why the Supreme Court has whittled away at Bivens actions and barring suits against immigration officers, and suggest what options can be employed to remedy this discrepancy for those who understandably are disappointed in the least or angry in the most as to why federal law enforcement apparently gets favorable treatment. So yes, civil suits are uphill, but uphill does not mean imaginary. And none of it eliminates criminal accountability. You've probably heard another argument too. Why didn't she, Renée Good, just comply? And here's the legal reality. A citizen must comply with lawful orders, but whether an order is lawful depends on who gives it, why, and under what authority. ICE agents do not automatically have traffic enforcement authority. They do not automatically control public streets, and conflicting commands matter legally and constitutionally. You take, for example, when Renée Good was there kind of blocking, there were still about, it was counted in the video, about 11 cars that did get by, including an ICE agent car. But there are a couple commands it seems that the jury could hear. One was to move the car and one was to get out of the car, you know. Now, I'm not here to say whether Mr. Ross, the ICE agent who shot Renée Good, is civilly liable or is criminally liable. My job here is just to share the law. What are the facts, okay? To help my listeners to be more informed about the context in which a jury is having to make that decision and what they're looking at, okay? So conflicting commands can matter in a lawsuit. Whether there are conflicting demands, whether it really makes a difference in this case, it's going to be up to a jury. It's not going to be up to us. It's not going to be up to me watching a video or you. You may, or I may, have our kind of opinion, but when it's scrutinized under the rules of evidence in a court of law in a more sterile environment with a judge ruling on objections and ruling on evidence, you see, ladies and gentlemen, that's where we try to get to the truth. So compliance does not erase the government's duty to act lawfully. This episode isn't about ideology, as I tried to state a moment ago, in a way. It's about accuracy. When government officials declare immunity, however, in this case as they did, before an investigation is complete, they undermine trust, not just in law enforcement, but in the rule of law itself. Hence why I caution people, be careful about drawing a conclusion when we may end up in a case, whether civil or criminal, where a jury will be making a decision using very well-tested rules and laws. Accountability is not anti-police. It is pro-Constitution. I presided over cases where officers did everything right and accountability protected them. The law does not demand obedience at gunpoint. It demands reasonableness under the Constitution. So let me leave you with this. Video doesn't vote. The Constitution doesn't campaign, and immunity is not obedience. Absolute immunity does not apply here. Qualified immunity is not a criminal shield, and accountability is not optional. But before we go, there's been an additional development that is important to note. According to reporting by the Washington Post and the New York Times and about every news outlet imaginable, the Department of Justice initially opened a civil rights inquiry into the ICE agent's shooting of Renée Good after the FBI determined there was sufficient basis to investigate. That decision was later reversed by senior Department of Justice leadership, who publicly stated there was no basis to open an investigation at all, despite the existence of synchronized video evidence and unresolved factual questions. That reversal, quite frankly, is unusual. The threshold to open a civil rights investigation is intentionally low. Opening an investigation does not presume wrongdoing, however. That's important to know. It simply allows facts to be gathered, witnesses to be interviewed, and evidence to be evaluated before conclusions are drawn. Declining even to investigate sends a message, not just to the public, but to the field of those ICE agents out there working. And when that message is combined with the reality that civil remedies against federal officers are limited, especially after the Supreme Court's narrowing of Bivens' actions, it risks creating a perception of insulation from accountability. That perception matters. The United States has not historically experienced federal law enforcement deployed in large numbers inside American cities. Our modern immunity doctrines and remedial frameworks were never designed with that reality in mind. When criminal review is foreclosed at the investigative stage and civil remedies are largely unavailable, the accountability ecosystem collapses, not by design, but by omission. That gap is something we need to be willing to examine honestly. That's the law, and that's the Teske brief. Thank you for joining us, and everyone take care and be safe.